Hello, my name is Brian Cronin. Welcome to part 2 of the tutorial Legal Opinion EQE paper D2. Part 2 is about legal consequences and planning. Let's start with a short introduction to the tutorial. The tutorial is presented in 3 parts. Part 1, assimilating and organizing information, which I hope you have done. Part 2 is legal consequences and planning, which is the present part. And part 3 is the legal opinion and comments, which will finish the tutorial. I recommend that you follow the tutorial in this sequence, so we can now go ahead with part 2, which is concerned with developing legal consequences and preparing notes to plan the legal opinion. Here is some follow-up to what we did in part 1. In part 1, assimilating and organizing information, we focused on the questions raised by the client. We tried to anticipate what information we needed to answer these questions. We scanned the client's letter looking for this information. Then we started to organize the facts that would produce legal consequences relevant to the questions, and we grouped the facts for each question, and we made a preliminary date scan that started a date diagram for each situation and placed each situation in date perspective, which I think is most useful. Here then is an overview of part 2, planning and developing legal consequences. Our planning has to be such that we develop legal consequences of the situation that are relevant to each of the client's questions, and we have to progressively organize the facts into a set of notes for answering the client's questions. Our future legal opinion will be a string of facts, a legal string that produces legal consequences, paraphrased legal provisions, and the ensuing legal consequences and advice. Our set of notes that we develop will reflect this legal string without the filler words that will make up our legal opinion. First, some words about dates. In a patent law situation, all dates are potentially significant. Before you tackle a D2 complex legal situation in exam conditions, it is important, it is imperative that you master the legal intricacies related to dates. However, if you are beginning your preparations, analyzing date-related D2 complex situations under non-exam conditions is a good way of becoming proficient in mastering legal intricacies related to dates. A good way of analyzing a date-related situation is to make a date display or a timeline in which events are organized in their time sequence relative to one another, which we saw already in part 1. We have already organized the basic situations into time sequence in part 1. Now we can extrapolate future events by entering legal time periods. You can then read off time-triggered legal consequences and transfer these legal consequences to your note sheets for the relevant question segments. Let's put this into practice by completing the preliminary date diagram we prepared for the situation of printing machine M plus A. I've presented an incomplete date diagram in part 1, but of course we can complete our diagram progressively as you go on. In other words, I'm going to present now a complete completed date diagram, but in practice you will build up this date diagram gradually. The initial fact-based diagram is indicated in black. The added extrapolations are in red. The idea is that as you analyze the situation, you will add and complete your notes to your note sheet for the situation M plus A. We'll do that next. What can we see on the diagram? Looking from the bottom of the diagram, we have the old printing machine, which is prior art. M plus A for EPZ is going to be patentable because we have an effect for the feature A, and we're going to be able to justify the patentability of EPZ. EPZ, if we look on the left-hand side, I put in an 18-month time period to September 2013, which was the publication or the approximate publication of EPZ, and it is 54.3 against EPX1, and it's 54.3 also against EPZ is non-prejudicial, however, against EPX1. We'll see that when we come to writing. If we go up, we have an 18-month timeline for EPG, takes us to November the 13th, which is the publication of EPG, which is 54.3 against EPX1. And then if we go up to the top of the chart, we'll see the final decision of the German court was the 15th of January 2015, and against that decision there was a 3-month period for filing or refiling EPZ under Article 61(1) EPC. So we've entered that date, 15th of April 2015, as the limit date for refiling EPZ under the conditions of Article 61(1). And then we have looked up into the future that the granted refiled EPZ will give typograph X dominating protection for M plus A in Europe. Once the M plus A has been refiled as EPZ2, it's going to give dominant protection for M plus A in Europe, which is good news for the client. And on the right-hand side, I put there that it would be a good idea to request early publication and accelerated grant under the PACE program, and to validate the patent in designated states, including Iceland. Next, we go to the completed notes for M plus A for question 1, the current situation. Other notes are going to go on the improvements to the situation. Will go into our notes for question 3. The completed notes that we have here represent a tidied up version ready for writing the opinion. As you assemble the notes, you should gradually organize them into a logical sequence, and these notes represent the current situation of M plus A as I perceive it. So let's go starting from the top and going down to the bottom. EPZ is a first filing for M plus A, March 2012 by Druk Z. EPZ was published September 3013. It should be 2013. There's a slight mistake there, I think you can correct. And we know it was published because of the search report, and we know because of the public inspection. It's important to establish that EPZ was published in time. EPZ was withdrawn in November 2013 after publication. The old machine M was prior art against EPZ. EPZ is novel by feature A, which allows increased speed. This supports inventive step. So EPZ was patentable, but it cannot be revived because it's been withdrawn. Your EPX1, which is the client's EPX1, covers M plus A and was filed in July 2012. EPZ is 54.3, but I say is non-prejudicial because of it was filed in evident abuse, and therefore whether it can be applied as prior art is questionable. EPG describes and claims M plus A and M plus A plus B. EPG was filed May 2012 and published November 2013. EPG's M plus A claim lacks novelty over EPZ, Article 54.3. EPG is 54.3 against XP1, so XP1 lacks novelty over EPG. As a result, there is no protection for M plus A in Europe, and the court decision from the German court on M plus A is not self-enacting, therefore it does not come into force yet. That summarizes what I intend to say about the current situation of M plus A. We'll see in part 3 how the notes serve as a framework for writing the opinion. Next, the completed date diagram for M plus A plus B. Starting from the bottom of the diagram and working up, we have M plus A plus B is inventive of EPG, is inventive over the old machine M. The M plus A claim lacks novelty over EPZ and therefore will not be granted. EPG is published in November 2013. EPX2, which is filed 10th of March 2014, has a claim to M plus A plus B, but it lacks novelty over EPG, Article 54.2. EPX3 has a claim to M plus A plus B, but it cannot be validly claimed because it lacks novelty over EPG. And if we glance into the future, we can say that ICPRG, which is the Iceland company, can obtain a valid patent for M plus A plus B, but not for N plus A. And this patent on M plus A plus B covers and dominates the client's M plus A plus B plus C plus D. That is relevant to question 2, the freedom to operate. Okay. Patentability of M plus A plus B is relevant to the current situation. So now we turn to the completed notes on the current situation for M plus A plus B. As before, I've completed the notes and organized them with a view to writing this segment of the opinion. You have to organize your own notes according to your own perceptions. So starting from the top, EPG describes and claims M plus A and M plus A plus B. Filed May 2012, earliest filing date for M plus A plus B. Only prior art, old machine M. EPG is novel over M by features A plus B that allow to increase the speed of the machine and to use different types of paper, which supports the inventive step. So IPRG should be able to obtain a valid European patent covering M plus A plus B, but not M plus A. It's continued on the next slide. EPX2 includes a claim to M plus A plus B. Its filing date is 10th of March 2014. EPG was published about November 2013, so claim M plus A plus B is not novel over EPG under Article 54.2. The client, that is typograph M, will be unable to obtain valid protection for M plus A plus B from EPX2. ICPRG alone will have patent rights to M plus A plus B. And the broad claim M plus A plus B will dominate or cover M plus A plus B plus C plus D. Next is the developed date diagram for M plus A plus C. So starting from the bottom of the date diagram, we have M plus A plus C of PCTL is inventive over the old printing machine M. On the left-hand side, we project a date of 30 months until 8th of April 2015 for completing the EP national phase or national regional phase of PCTL without surcharge. If we look at the 10/3/2014 date, EPX2 is filed, but if PCTL enters the EP regional phase, it will become 54.3 prior art and will destroy the novelty of M plus A plus C of that claim. And we put notes here at the top. If PCTL enters the EP regional phase, it will become 54.3 prior art against EPX2 and destroy novelty of its claim M plus A plus C, as we've just seen. In this case, PCTL will be able to obtain valid protection for M plus A plus C in the maintained countries. And then, on the other hand, in the paragraph just below, if PCTL does not enter the EP regional phase, it will have no prior art effect against EPX2, so typograph X will be able to protect M plus A plus C by EPX2. There again, these different extrapolations concern either the current situation, the freedom question 2, or improving rights question 3. And next we'll turn to completing and organizing the notes for M plus A plus C for the current situation. There will be further notes for question 2 and question 3, freedom to operate. So here are the completed notes on the current situation of M plus A plus C. PCTL is filed 8th of September 2012 by Print L. This is a first filing for M plus A plus C. The prior art is machine M. EPZ M plus A was published too late to be prior art. PCTL is novel by the features A plus C, which increase speed and use different types of paper. This supports inventive step. PCT should obtain valid European patent covering M plus A plus C in the maintained countries if PCT enters the EP regional phase by 8th of April 2014, which is the date without surcharges, and it validates after grant. And then the protection for M plus A plus C broadly covers M plus A plus B plus C plus D of the client. We will continue over. EPX2, filed 10th of March 2014, covers M plus A plus C. If PCTL enters the EP regional phase, it is 54.3 prior art against EPX2, which will destroy the novelty of claim to M plus A plus C. In this case, Print L and not typograph X will have protection for M plus A plus C. On the other hand, if PCTL does not enter the EP regional phase, PCTL will have no 54.3 prior art effect. Typograph X will be able to protect M plus A plus C via EPX2, and in this case, print L forfeits protection for M plus A plus C in Europe. And the last note is that outside Europe, PCTL can protect M plus AC in maintained countries. I observe that as I'm finalizing these notes, I'm rehearsing for the opinion to be written. You can and advantageously will do the same. Next, we turn to the developed date diagram for M plus A plus B plus C. So EPG is published in November 2013, and it's prior art for M plus A plus B. EPX2 is the first filing of M plus A plus B plus C. Its time for refiling under priority, it's the first application for refiling under priority, is 12 months later, 10th of March 2015. EP2's distinguishing feature is C. The effect is that it reduces misprints. This supports inventive step. By refiling a PCT under priority, client can expect to extend protection outside Europe. M plus A plus B plus C of EPX3 will not lead to valid protection. Protection of M plus A plus C from EPX2 will be dominated by M plus A plus B, EPG, and M plus A plus C, PCTL, if validated. Let's now see how the completed notes on this situation look. EPX2 is first filing for M plus A plus B plus C, 10 March 2014. Closest prior art 54.2 is M plus A plus B, which is EPG, published November 2013. M plus A plus B plus C is novel. The differentiating feature C alone reduces misprints, and B plus C reduces noise, and these both support inventive step. EP3's M plus A plus B plus C lacks novelty 54.3 over EPX. Typograph X can get valid protection in Europe for M plus A plus B plus C from EPX2, and can get protection outside Europe by filing a PCT under priority. However, there are dominating third-party patents, M plus A plus B of EPG and M plus A plus C of PCTL, which will dominate the client's claim to M plus A plus B plus C. So we turn over. There is a 2-month deadline from 20th January 2015 for the court's decision, namely, there is a 2-month deadline from 20th January 2015 to 20th of March 2015 for filing missing parts to cure insufficiency and redating of EPX3. All that is for question 3, improving. XP3 is invalid, EPXP3 is invalid because of an insufficient description, and it's no good for claiming priority. That is part of the present situation. And there is no current valid protection for M plus A plus B plus C plus D but the patentability of that invention is intact. There has been no public disclosure of D. Note on the future PCT will go under question 3, improving. Note on domination will go under question 2. Now the notes on the current situation. EPX3 is the first and only filing for M plus A plus B plus C plus D, 20th of January 2015. EPX3 has an insufficient description. EPX3 is invalid. Because of insufficiency, it cannot serve as a valid priority claim to M plus A plus B plus C plus D. Currently, there is no valid patent application for M plus A plus B plus C plus D. However, the patentability of M plus A plus B plus C plus D is intact. As D was not visible, no publication took place at the trade fair, and there was no disclosure of the feature D to anybody. Now we turn on the notes on question 2, freedom to operate. Freedom to operate is compromised by any third-party patent on A plus B, M plus A plus B plus C plus D, or any broader subcombination of less features with M plus A. However, there is no third-party patent on M plus A plus B plus C plus D. There is a dominating M plus A plus B EP patent which should be granted to ICPR-G. There is a dominating M plus A plus C EP patent that should be granted to print L if print L enters the EP regional phase. These patents are enforceable after grant against MA plus A plus B plus C plus D in maintained countries, and there is pre-grant provisional protection, no enforcement before grant, reasonable compensation. That's it. Now we turn to the notes on question 3, improving rights and improving position. For this, I've divided my notes on improving rights into subcategories for each machine type, and my notes on improving position relative to each competitor, IPCRG and print L for each competitor. So let's start with improving M plus A. Here then are the notes on improving M plus A. Within 3 months from court decision, by 15th April 2015, file new application, refiled EPZ, like a divisional, filing date of EPZ, OK if EPZ withdrawn. Provisional publication protection from publication. Early publication pace, accelerated search pace, accelerated exam pace. Granted claim M plus A dominates all machine developments, including M plus A plus B of EPG of ICPRG and M plus A plus C of print L. Validate the patent in all useful countries, including Iceland. Next is M plus A plus B. Typograph X cannot protect M plus A plus B. There is nothing to improve. M plus A plus C, maintain M plus A plus C in EPX2 application in the hope of protection if PCTL does not enter EP regional phase. If PCTL enters regional phase, limit EPX2 to M plus A plus B plus C. If PCTL does not enter the EP regional phase, pursue EPX2 to grant for M plus A plus C, and M plus A plus B plus C. Next, notes on M plus A plus B plus C. Typograph cannot get valid protection for M plus A plus B plus C in Europe from EPX2. Typograph, can get valid protection in Europe for M plus A plus B plus C from EPX2, but this protection is dominated by M plus A plus B of EPG and M plus A plus C of PCTL if validated. Note, M plus A plus B plus C is not currently offered by competitors. No particular need to accelerate. Allows EPX2 to proceed at snail's pace, slowly. Typograph X can get valid protection for M plus A plus B plus C outside Europe by filing a PCT claiming priority from EPX2 by 10 March 2015. Next are my notes on M plus A plus B plus C plus D. First plan is a plan for protection in Europe. Salvage EPX3, file missing parts by 20th of March 2015. The filing date is shifted to a new date. Post-dating does not compromise patentability as D was not publicly disclosed at trade fair. Closest prior art is M plus A plus B plus C, which is a display less D. Differentiating feature reduces ink consumption, therefore there is an inventive step. EPX3 will lead to valid protection of M plus A plus B plus C plus D in Europe. Next is Plan B, protection also outside Europe. Plan B, protection also outside Europe. If protection outside Europe is of interest, promptly file a new PCT application with sufficient description and claim to M plus A plus B plus C plus D. Pay the PCT fees as this is not a priority setting application. I'm not sure what I mean by the next phrase, if protection for M plus A plus B plus C. Yeah, I think there's something missing there which will come in my answer. This is if protection for M plus A plus B plus C, this is plan 3. Combined protection of M plus A plus B plus C and M plus A plus B plus C plus D outside Europe and to reduce costs. File a new PCT application, description and claims MABC and MABCD. Claim priority of EPX2 filed by 10 March 2015. Claim to M plus MABC entitled to 10th March 2014 patentable over EPG. Claim to MABCD entitled to PCT filing date patentable over M plus A plus B plus C display. And I put a question mark. There's a possible problem for unity, which I will discuss in the opinion. That finishes the notes on improvements of the rights to different machines. Now we turn to improving the client's position vis-à-vis competitors. Start with ICPRG. File third-party observations against EPG, cite EPZ, point out 54.3 status. If M plus A is not removed before grant, file opposition. Accelerated publication of refiled EPZ gives provisional protection. Translate claim in Icelandic language for provisional protection. Early grant of EPZ gives dominating protection for M plus A and M plus over M plus A plus B. When refiled EPZ is granted, validate in Iceland. In due course, validate other granted patents in Iceland. Validation implies filing claim translation in Icelandic. More on ICPRL on the next slide. Inform ICPRG about the court decision EPZ02. Inform them about dominating protection for M plus A covering ICPRG's interests. ICPRG may not, or possibly may not, be motivated to protect PCTL in Europe because its activities are limited to Iceland, because of the costs of validating EPG, expensive, and because EPG will be dominated by EPZ02. Therefore, the client can propose to ICPRL that typograph alone will protect M plus A plus B in Europe at its own cost by taking over EPG. In compensation, offer the Iceland company a free license for M plus A and M plus A plus B in Iceland and possibly other territories. Failing this, propose a form of cross-license. Next is print L. Vis-a-vis print L are interested mainly in the Asian market. They mention possible cooperation in deciding national phases for print L, and M plus A plus C is dominated by M plus A. There's only a short time after the next meeting for validating print L. Encourage print L not to validate in Europe, expensive, leaving the way for typograph X, giving a free license for print L in Europe for M plus A plus C. If print L goes ahead in Europe, propose a form of cross-license. And now some closing words. In part 2, we developed legal consequences of the situation relevant to each of the client's questions using date diagrams. We progressively organized the facts and legal consequences into a set of notes for answering the client's questions according to the structure of the client's questions. Our future legal opinion will be a string of facts, paraphrased legal provisions, and the ensuing legal consequences and advice expanded from the notes. We will deal with developing the legal opinion in part 3. This then is the end of part 2 of our tutorial on paper D2 of the EQE. Please continue with part 3, the legal opinion. À bientôt.